Good evening. This is Rahul Reddy, live from Houston, Texas. REDDY NEUMANN PC does bring weekly immigration news. For those people who have not subscribed or liked our Facebook, please subscribe to the YouTube or like in Facebook and subscribe to our newsletters. Emily, what do we have this week?
So this week we have big news on the immigration legislation front. The Fairness for High-Skilled Immigrants, H.R. 1044, is supposed to be voted on in the House either this evening or tomorrow, I believe, is what the latest we've heard. So that could be big news. We're going to be talking about site visits that are seem to be happening under the STEM OPT 983 training plan regulation that went into effect back in 2016. Talk a little bit about automatic visa revalidation, what it's used for, who can benefit from it, and why you might want to use it, as well as issues with third-party placement where the worker is on a visa and being placed at a client site or some other location other than the company that's sponsoring them, and what are the kind of special issues that arise in that situation.
Emily, discussing about this per country quota limited, I've been an immigration lawyer for 24 years. I've been an immigrant into this country. When I actually just got the green card, the backdated things were published. I got the green card in June of 1996. By the time I got the green card, they already published the visa bulletin for July, and it was backlog from July. Had I not got the green card on that month, I'd have been stuck for 5 months. And I know people who have been stuck for decades in this thing. Been fighting this one. Now, I know in our previous versions, we gave 0.5%, and then I moved to a 20% approval chance. What do you think, so at this point of time, that this will become a law and people can avail the no per country limit?
Yeah, that's a tough one. I mean, I think that it seems very likely that it'll pass the House. I mean, it already had 311 co-sponsors, and it only needs 290 votes to pass. So then it's going to be up to the Senate, which I think there the chances are low. I don't know if I would say 25% chance of the Senate passing it. Their version might be different, and then we have to go into conference, and then will the president even sign it is going to be another question. So I think that it still has a long way to go. Chances are still relatively low that it will actually become law.
What do you mean by low? Give a percentage.
I'm going to say 10% chance.
I'm going to be sticking at the 25% chance at this point of time, Emily. Of course, we can vary based on it. Here's the reason why I think so. This is Joel Lofgren has been trying, Congressman Joel Lofgren has been trying for this bill to be passed for a long time. However, we have seen that there is an agreement between Senator Lee and Senator Grassley on this bill. We know for sure this is going to be passed through the House. I'm not expecting much hurdles in the House of Representatives, but when it goes to the Senate, the upper house, as you said, yeah, the chances are not as bright as in the lower house. I might have a little bit more hope on the Senate all this time because there are some amendments which Senator Grassley is trying to amend it. I think so Joe Lofgren might take that pills, even though they are not good for the immigrants. She might take those pills and might pass this legislation back in House. I am thinking that there is some positiveness in there. We have seen that in the Senate, the similar bill, Senator Rand Paul has put a hold on it. That means that it requires 60 votes to take it off. We may have a chance because of Senator Grassley might be in favor of. I want to have people talking points when you are contacting the congressmen, when you're contacting the senators, when you're contacting the media. A lot of misinformation is there on this bill, Emily. The misinformation that I'm looking at is that in some of the conservative news channels is that they're telling that this is going to benefit Indian nationals only. And I don't see anything in the bill that is benefiting Indian nationals. All the bill is doing is that it is stopping discrimination. There is no word of India anywhere. All they're telling is that all nations will be treated equally. That doesn't mean that the bill has anything that says that it is benefiting Indian nationals. So when you're trying to contact the congressman or the senator or the press, I would recommend, my fellow immigrants, that this bill is not favoring India. It just is taking the discrimination off. There is a discrimination based on the national origin in this in the existing law. This new HR 1044 is actually taking the discrimination off. It's not particularly, there is nothing there in there that, okay, we're going to favor the Indians or Chinese. All they're telling is that everybody will be in the playing field. Now, of course, because some of the talented people who have been waiting for a long period of time will be benefited. It shouldn't matter for the Congress or anybody who those people are. That's all this bill is saying, is that based on the country of birth, we should not discriminate, and that's all the bill is saying. So when you talk to the congressman, tell that, this bill is stopping the discrimination. It's not favoring, it's just stopping the discrimination.
Yeah, I think that there's a lot of negative feelings towards this bill. You have, and it's understandable, people from other countries who've had the, I guess, benefit of not having a long wait.
Having a benefit of discrimination.
Right, they've been benefited by the discrimination, and so they don't want to see this bill pass. And of course, if it, when it's something that's harming you personally, or maybe not harming, but making you wait longer, of course you're not going to like it. But I think just in all fairness and treating everyone equally, when we're talking about employment, country of birth should not have any relevance at all.
Should not relevant. There was a comment that is made on our office by a conservative magazine. I don't want to name the conservative magazine. Racist for Profits is the name given to us. How do you defend yourself from there?
Well, yeah, so I've had comments on my blog suggesting those things, that because we work with a lot of Indians, this law is going to be really good for us as a law firm. And then I've also had people, Indians, tell me, well, you don't want this law to pass because it'll be bad for you, because then you won't have all the H-1 extensions that you can file for Indians anymore. So which one is it? I'm bad if I do, I'm bad if I don't. All I can say is I think that country of birth should be irrelevant. What you should be in line based on when you started the process. And then maybe, again, I understand that we're going to have backlogs for some people that have never experienced it before, but guess what? Once you start experiencing the backlog, I bet you're going to start fighting for immigration reform. Maybe this will be the momentum that gives us real reform, that changes the cap altogether, maybe raises the cap, maybe makes master's STEM students not subject to the cap, or EB1 is not subject to the cap. All of these things have been thrown out over the years, but never get anywhere, because the only people right now that are harmed by backlogs are Indians. But if everybody's harmed by it, maybe we'll actually make some progress.
Yeah, this bill is just trying to take the discrimination off, that's all. I would strongly suggest all the audiences who have been affected by it, when you're talking to the press, when you're contacting the congressman, please mention to them that it's just taking the discrimination off. It's not giving any particular nationals any preference, it's just taking the discrimination off, and it should be promoted for. This is the right time for you guys to contact the congressman. You can go to immigrationgirl.com and try to get the information from there, what the talking points are, and then from there you can contact the congressman. Please, when you contact the congressman and senator, just don't tell them that this is favoring Indians. It is not favoring Indians. It is just taking the discrimination off. That's all it is doing. So please, refine your talking points when you contact. Emily, on the H4 EADs, we have. I just want to have some updates on those things. And you've been filing litigation. We have some success in the H4 litigation where H4 is getting delayed. When the H1, H4, and EAD has been filed together, they were not adjudicating. H1 gets approved, H4 and H4 EAD is still pending. And we have got some good results from the litigation, because otherwise it may take ever for them. Any more things that you want to add on that H4 EAD?
Yeah, so after we saw some initial positive outcomes from our first lawsuit, we continued reaching out to individuals that are affected, and it's really amazing to see how widespread this issue is, so much so that we ended up filing a second lawsuit last week with 20 co-plaintiffs. who are all experiencing the same delay, who filed timely, filed with an H-1 in premium processing, got the biometrics done, their EAD is about to expire, they're about to lose their job, they've tried expedite requests. Guess what? USCIS says there's nothing to expedite because you're within normal processing time. I don't know since when that became relevant to whether you can expedite or not. That's the whole purpose of expediting, is to go faster than the normal process because you're going to face severe financial harm. So expedite requests don't work. Congressional inquiries don't work. Again, they just say it's within the normal processing time, you have to wait. So this litigation is the only thing that we've seen work.
Getting the results. Otherwise, so if anybody wants to, please contact our law office. We would be able to entertain in the next set of litigation that we are intending. We're intending to file every 2 weeks a litigation to get the benefits. Otherwise, it may take ever for you guys to get the H-4 EAD. Emily, you said that I started, Immigration and Customs Info started the site visits for STEM OPT, or do you mean by H-1Bs or STEM OPT?
Yeah, I meant STEM OPT. So
that was never there. What happened? What's the law and why is it right now?
yeah, so this stems from the 2016 regulation that created the 24-month STEM extension. So back in the day, since 2008, we had the 17-month STEM extension that had very few requirements or restrictions on it. That was struck down by a court in 2015, I believe, and then a new regulation was put in place of it in 2016 that created a 24-month STEM extension, but it added the I-983 training plan requirement. It added the requirement that the pay be commensurate with U.S. workers that are similarly situated, and that the supervision be happening between the trainee and the company that's providing the training. So as part of that regulation, it was included that ICE would have the authority to conduct site visits to ensure compliance. Now, why is it ICE? That's because the whole F1 student visa program is administered by ICE. It's not USCIS. So ICE is in charge of the SEVIS system, the SEVP portal, all of that is ICE. They monitor students to make sure they're in compliance. So we've started seeing some employers have received emails from the SEVP agency stating that they're scheduled a site visit on a specific date in order to verify that the employer is properly complying with the I-983 training plan that they signed for that student.
What are some of the common mistakes that you see with the employer and employees not following the I-983s in the STEM extension?
Yeah, I think not doing the 12 and 24 month reviews on time, not updating the 983 when your work location changes, and then I think just not actually following through on the training portion of it. And there's supposed to be contact between the supervisor who's training and the student. This is on-the-job training, but it is training. You're supposed to be learning something, not just working. And sometimes the employer is not actually in contact with the student very often, or they're not following through and training them on the things they said they would in that training plan.
Emily, on the issue of the automatic revalidation, I mean, what is an automatic revalidation and how does it work? When can people use it more effectively?
Yeah, so it's a very helpful provision that allows F1 or H1 or H4 individuals to travel to either Canada or Mexico for less than 30 days. And even if your visa stamp has expired, as long as you have a valid I-94 on an I-797 approval notice, you can use your expired visa stamp and your approval notice to come back.
Did you say expired visa stamp? Mm-hmm. So in other words, if my H1 visa is expired in May of 2019, I have a H1B extension until 2022. I can go to Mexico for less than 30 days and come back with the expired passport.
Right.
But with the 797 approval.
Exactly.
Okay.
Yeah, and the same is true with Canada. So this allows you to avoid going for visa stamping if you're going to only Canada or Mexico. Now, if you do go for stamping in Canada or Mexico, and you don't get the stamp, you can't use automatic revalidation to come back. So this is only if you don't go for stamping. One other thing to be aware of is it even works if your old visa is in a different category. So this is common for, say, someone who came on an F1, completed their studies, filed the change of status to H1, and has not gotten the H1 stamped yet. You can actually go to Canada or Mexico for less than 30 days and use your old F1 stamp, whether it's expired or not, and your new H1B approval notice that has the I-94 and re-enter. Now, who can this really benefit? This is really helpful for situations where there may have been a minor status violation, because travel is usually one of the main ways a status violation can be cured. And of course, anytime we're talking about a violation of status, you should certainly
consult
discuss
a lawyer
with
before you go to Mexico,
yeah, don't just,
and get stuck there.
Yes. So this is something that can clear up some small things without the need of having to go for stamping, and allows you to come back in and regain your status and continue going forward without having additional problems. So that is something, again, if you have any issues, always check with your attorney before you make any travel arrangements, and to determine whether travel is a proper way to solve it for you.
Emily, I've noticed that since the time the Trump administration has been here, we're having a lot more H-1B denials than that of the before this administration. In those denials, Emily, I have also noticed that, and then USCIS also published the H-1B hub, where the H-1B denials for the consulting company is way higher than those of the H-1Bs that have been filed for companies that are filing H-1Bs for people working in their office. Can you explain why is it different when you are filing H-1B for an employee who is going to work at the office location as compared to when he's working at the third-party location? What is the difference between when you're filing on the H-1B, and why are they discriminating? Why are they looking into the third-party placement quite different than that of the in-house work?
Yeah, I think the main idea here is we now have two different companies involved with the H-1B work. So which company is the actual employer? Is it the company where you're placed, that's you're doing the work for, or is it the company who hired you and sponsored your visa? And so in order to verify that the company that sponsored the visa is the actual employer, that's where you get those employer-employee relationship type of requests for evidence. They want to make sure that your actual employer that sponsored the visa is not just a token employer, but is your true employer, and they have the control and the right to control you. They're supervising you while you're at that client site, and the client is just using your services, but they have no control over the employment relationship. So that's kind of one of the issues, is verifying that your employer actually has the right to control, not the end client. And then the other issue that comes up is the question of, okay, who's deciding on the job duties? Is it your employer or is it the end client? And who is in a better position to tell USCIS what your actual job duties are? That's why you often see requests for evidence asking about specialty occupation for third-party placement, and they want to see the contract, the work order, the end client letter, so that they can see what the actual job duties are at that location and determine from there whether it's a specialty occupation. They're not just going to take the sponsoring company's word for it, since they're not on site with the employee. So I think those are kind of some of the major issues. And then for USCIS to make sure that work is actually available, it'd be pretty easy for a company to just randomly file someone's H-1B and say, yeah, I'm going to place them over here, but not actually have a contract with this company over there. So there's a lot of questions about the succession of contracts, verifying that all companies involved are aware of the placement and who the actual employer is, and that work is available, and again, that it's specialty occupation work. It's not a speculative situation where the person might be benched without a project.
Very many questions are coming on the bill, Emily. What was the likelihood of passing the bill in the House? Do we have enough votes to get passed in the bill? The last time I checked it was that it has enough votes to pass in the House, which is House of Representatives. It has enough votes to pass because there are about 80 to 90 Republicans, plus almost all the Democrats supporting this bill. So there will not be any discussion if the things go through as it is in the House. It has a good chance of in passing in the House. And I have to remind you that similar kind of bills were being passed in the House before. This is not a new thing that this kind of bill has been passed. But it's getting passed again to be sent back to Senate. So good chances in House, but we have to see how the things will go in Senate.
All right. This is kind of a situation we've talked about before from Vishnu Vardhan asking for a friend. His friend had a site visit. He's on H-1. But for the site visit, they were not asking about his current employment. They were asking about his very first H-1B employer that filed in the CAP, because that employer said this person was going to be working in-house. And he did work in-house for a very short time and then was contracted out to a client site. And wants to know kind of what the impact is going to be now. He's no longer at that company, transferred to a new company. We're seeing a lot of revocations of approved H-1Bs that were filed in 2015 and 2016 for this exact situation, where the company filed saying they had some big in-house project. They filed hundreds of H-1B petitions, got a bunch of them approved, and guess what? No project existed, or maybe they worked on that project for a month. They were just waiting until they could find a real project and then put them out in a consulting position. So USCIS is revoking those first petitions. And when they do, the risk is that if it's revoked due to fraud or misrepresentation, it's treated as if that petition was never existed. It was never approved. Therefore, you've never actually been counted in the CAP. So even if you've later transferred or filed extensions, that revocation could follow you, and they could come to revoke later petitions because you haven't been counted in the CAP. So definitely need to talk to an attorney about that to see what the chances are of that happening, depending on exactly what the situation was with that first approval, and determine whether any action needs to be taken now to preempt any kind of revocation that might be coming.
Dang has this question on this bill, Emily, is that from YouTube. He's saying that does this bill means that it's going to put non-Indians and non-Chinese at the bottom of the list?
That's a great question. It's going to put everyone in line based on when they got in line. So if you just got in line, yeah, you're going to be at the bottom of the list. But if you got in the line 5 years ago, you'll be in line with everyone else who got in line 5 years ago.
So this bill will not place anybody over or below. Everybody will be treated based on when you file the application.
I have a question on the bill as well that maybe you can answer. How much will the backlog improve for Indians? Where do you think the dates will move to? If
I'm
it's
expecting
passed?
between 2015 and 2016, Emily. There's an article written on 108 years waiting period for the employment-based immigration for people who are born in India. You can check that article, and the numbers have been there based on the numbers that have been filed, labor and I-140. I'm expecting between 2015 and 2016 in the first year, that is starting in September. There's another question that is coming on the bill is that what will happen for the people who already filed the adjustment of status application. If you have already filed the adjustment of status application, and if your priority date is backlogged, in other words, let's say you filed under the general quota and then it's backlogged, they will keep your adjustment of status pending until your priority date becomes current. You'll be issued an EAD or advance parole. In cases if your priority date is before the priority date they publish, they will adjudicate your application because it will be based on when you file the adjustment of status, and then your application should get adjudicated sooner than those people who will be filing in October 1st.
Okay, I had a question about the H-4 EAD litigation that's been going on, not our litigation, but the lawsuit that was brought by Save Jobs USA trying to end the H-4 EAD. This lawsuit's been going since the H-4 EAD first came out. And so the latest update I have on that was from back in April, when Homeland Security, who interestingly has to argue that the H-4 EAD is valid, at the same time they've got a proposed regulation to take it away, had to submit its brief in court basically saying that Save Jobs did not have standing to challenge the rule because they couldn't prove that their members were harmed by the H-4 EAD, which again is very ironic considering that's why DHS is claiming they need to get rid of the H-4 EAD is because it's harming supposed U.S. workers. But that was back in April, so that was kind of the first round of briefs back then, and I don't believe there's been any updates since then. There were additional briefs that had to be responded in late April. No decision has been made by the court, and I haven't seen any filings recently.
Vikas has this question. Once the 1044 bill has been passed, how long does it take for the Senate to get approved? That's $1 million question. It may be passed soon. It may never be tabled in Senate. This kind of bill was being passed in House before. It was never tabled in Senate. This time there are a little bit better chances, but there is, it may go through fast or it may be there for a lot of time or never be placed. Another question from Abhilash. Very good presentation, very good question he asked. Question of the day. Airport authorities recently started taking random photos of immigrants before boarding. What's the deal about it? Abhilash, I was in a meeting last month with the CBP officials. They said that they are moving away from a manual passports that they are having right now. Everybody will be identified with the facial or eye recognition. I don't know how that works out. So when you're boarding, not only here to outside the country, when you're boarding in whichever country you're coming in, they will have every camera there, and that information will be passed. If you're telling they're taking random pictures when you're boarding, no, they're having video recording everything, and they're having facial recognition, or they're already doing in most of the places. In fact, the CBP official said that passport will be redundant pretty soon. Everything will be based on facial recognition. That's the way he sounded that. And it may happen pretty quickly where just we walk in, they see our face, everything will be read, and then we're allowed in, or they might ask questions. I've seen the movie with Tom Cruise, and that is more likely to happen right now. We do have facial recognition on smartphones right now just to open up. It won't take that much time to implement the same thing in the CBP, so most probably it will be soon coming through.
Couple questions. Karun wants to know how many senators are supporting the Fairness for High-Skilled Immigrants Act as of right now. I believe there are 34 co-sponsors for the Senate version of the bill, which is S386. Kavya wants to know if the district court in North Carolina issued suspension of the USCIS August 9th memo. So this is the unlawful presence memo for F1 students. So the court issued a temporary or a preliminary injunction that stops USCIS from being able to enforce the memo, but the court has not actually decided the case. So we still have to wait for the court to go through the whole process of hearings and briefs and all of that before it finally makes a decision about whether or not that memo is valid. So right now it's just temporarily on hold. The court could, a year from now, decide, nope, USCIS did have the power and did do it properly, and therefore the memo takes effect. Or they could come back and say this memo should have never been in place in the first place, and therefore they're enjoining or stopping the memo from taking effect at all. We just don't know which way it's going to go yet.
Mr. Roy has this question from YouTube. Is this bill going to affect only EB2s and EB3s, or is it going to be applicable to EB1? It's applicable to EB1 also. All employment-based, including EB5.
Question on green card interview. It's been more than 90 days since the interview, still no decision. Are there any issues with that? Is that pretty normal these days?
That's kind of long. If the priority date is current, they should have been adjudicating the petition. I would raise a service request if it's been 90 days and they have not adjudicated the petition. I'm assuming that the priority date is current. If the priority date is not current, they cannot technically issue a green card. So it's right for them to keep on holding. But if the priority date is current, 90 days is pretty long time. You should contact the USCIS.
Maheshwar's wife recently lost her job while she's on H-1B, and he wants to know if it's better for her to file a change of status to H-4 or exit, get the H-4 stamp at the consulate, and come back into the U.S. So first, I would remind you that in the situation of a job loss, if the I-94 is still valid, you do have the 60-day grace period that gives you time to potentially file an H-1B transfer to a new employer if you are able to get a new job offer that quickly. If that's not looking like a good option, getting the H-4 stamped is definitely a much faster process, obviously more hassle because you've got to travel, get the visa interview appointment, attend the visa interview, wait for your passport, hope there's no 221G and all of that mess. But it's certainly going to be a lot faster than filing the change of status to H-4 because the I-539 processing time is anywhere from like 4 to 15 months, depending on which service center it ends up at. And you've got to do the biometrics. That slowed everything down. So really kind of depends, do you want less hassle and longer process or more hassle and shorter process?
I need some attention from you, Emily, in this one. Jeevan is, from YouTube is asking this question. He wants to change from H4 to F1. Is it better to apply for change of status or is it better to apply for the consular processing?
So first I would say I would be careful about this and really look into the situation and what the reason is for the change of status. The one situation where switching from H4 to F1 makes total sense is if you are an H4 child who's aging out, turning 21, where you can't extend your H4 any further and you're going to school, it makes perfect sense to switch to F1. Now, as far as whether you file the change of status or get the visa stamp, both of them have their difficulties with getting the visa stamp. You know, it's going to be up to the discretion of the consular officer whether you're able to prove you have your intent to return to your home country at the end. Now, if you are a child who's lived here for 10, 15 years, and now you're going to college, your parents are here, your siblings are here, how are you going to prove to a consular officer that you intend to leave the U.S. when everyone else is here? So that may be difficult to get the F1 visa stamped. Also note that the change of status to F1, as I just mentioned, the processing times for I-539s can be extremely long, and you have to be aware that your start date on your I-20 is going to be changed while you're waiting for your F1 to be approved. And if you don't file an application in between to continue your status, your F1 could ultimately be denied a year from now. So it's called a B2 bridge if you're not able to extend your H4 further. You may have to file 1, 2, or 3. You have to file every 6 months until you get your F1 approved. So just be aware of the long processing times and the extra steps you need to take. A lot of schools, you know, the DSO at the school, they're not an attorney. They're not supposed to be advising you on legal issues. And so they may not inform you about this issue of having to file the B2 bridge. So just be very careful of that if you're planning on changing status.
Kishore has this question. I really want to answer this question. I never got the occasion to answer this question. At the port of entry, he was removed from his luggage. Millets, pulses, and other things were been removed. He was never been fined. He was let go into the country without, after removing the food items. Will he have any problem in filing the adjustment of status? Will it affect his immigration? Kishore, it will not affect you. But here is what I want to take this question go further, Kishore, is that it will not affect you. But what I'm advising you is that, Kishore, don't bring any food materials. I try to look into the CBP and find out what can be bought, what food material can be bought into the country, what food material cannot be bought. It's a list that is not a laundry list. That is, I don't know what list it is. It is so long, and I took hours and hours. I couldn't configure what I can bring, what I cannot bring. Now, what would I do when I travel back into the country? Number one, I will not bring any food material into the country, period. I don't want to take chances. I'm a US citizen. And if you're an immigrant and you're trying to bring the food material, don't bring. That's my simple advice. Now, having said that, there are a couple of things that are simple mistakes people have done, Emily. I mean, in the airlines, they give an apple or an orange. I mean, it's a nice fruit. Fruits are good to be eaten. And then, people try to bring from the airplane into the country. That you cannot even bring it from the airlines itself. When they give a fruit, you can't bring into the country because it is a fruit which is not a dry fruit and which is very dangerous to come into this country. There are things. So be careful on those simple things. My advice is don't bring it. That's the best way to avoid it. Now, I have seen some people getting into trouble, and some people like you, Kishore, you did not got into trouble. That's good to know. I've seen some people who got into trouble. They asked the question on the customs, are you bringing any food material in there? They answered no to the question, and they went in, they checked in, they got into trouble. That's a criminal case. I do not advise you do that thing. My simple thing is just don't bring it. If you're bringing in, check in the CBP data what you can bring in, declare it on there, and have it checked by the CBP official to see if you can bring in. And anything which is live or fruits which are not dry fruits, don't bring them, period. No mangoes, please.
Krishna has a question. One of his friend's wife is working on H-4 EAD, and he wants to know if she can apply for the green card process. And this is a really common question because everybody thinks you need to be in H-1B status only to be sponsored for the green card. And the answer is yes. Even if she's on H-4 EAD, her employer can file a perm on her behalf, and then the I-140, and then when her priority date becomes current, she can file the I-485 straight from H-4 without ever being on an H-1.
Amit Kumar has this question, Emily. I want your attention also on this one. He has multiple H-1B approvals, extensions from the same company. Now he got the denial. Can he go and file a lawsuit against USCIS?
Oh, he's had multiple extensions over the years?
Yes.
Yeah, so all of a sudden, that seems to be the common thing these days is without having deference to prior adjudications, because USCIS got rid of that memo, people who've filed years and years and years, every 3 years getting their extension, all of a sudden they get one denied. Yes, a lawsuit can be used to overcome an H-1B extension denial. You are filing on the grounds that the denial was arbitrary and capricious in violation of the Administrative Procedures Act. There has to be a rational reason for a denial, and especially if you can show that from the last petition to this petition, everything's the same, clearly that's arbitrary. There's no reason that you would have a different result because the law hasn't changed. So yeah, that is a great case.
You said that the USCIS has changed its opinion, and you said the law has not changed. What's the difference between that?
Well, yeah, so typically when we start seeing different decisions from the same set of facts, it would be based on some change in law or some change in regulation. So a law is something that Congress and the Senate have to pass a bill and that gets signed by the president. A regulation is the agency that's charged with implementing that law comes up with ways to fill in the gaps, because laws are generally very vague and kind of big picture, and now the agency has to actually implement the law, so they create regulations which everyone has to abide by. And so if the law hasn't changed, the regulation hasn't changed, it would make sense that you would get the same decision that you got last time. So showing that there has been no change, yet all of a sudden we have these different interpretations by USCIS, it's ripe for litigation. It's a good situation where you can file a lawsuit, and in that lawsuit, you may be able to ask for a preliminary injunction for the court to cause you to stay in status while the case is being adjudicated by the court. Whereas if you file an appeal with the Administrative Appeals Office, there's nothing keeping you in status while you wait. So it's definitely something that I would look into further.
Srinivas has this question. His daughter is turning 21 on November 2020. He wants to file the H4 extension. Does he need to include her in a different package or the same package? Or you can include on the same package. However, her approval will be limited up to her date of birth. She will not be given when she turns 21. So on November, her approval, even though your H1B might be granted until 2022, and your wife's H4 will be granted until 2022, your daughter's will be granted only until November of 2020. If by any chance they do the mistake, don't count that one. November 2020 is her H4 ends. And I want you also, Srinivas, to be careful with your daughter, because once you get the premium processing approved, you may want to file a student visa right now if she's going to college, get an I-20 and file a student visa, because in some instances it's taking 18 months for them to adjudicate the student visa. And she has to maintain the legal status. And she's turning 21, she's going to go out of status. So it's better that you file the student visa change of status immediately as soon as you get the H4 approval until November 2020. Anything you want to add?
I want to add on the I-539, when you have your spouse and your child filing together in one application, you have to ask for the same end date. So if your child is aging out to where they would be getting a shorter approval and you file them in one application, your wife's going to end up also with a shorter approval. So it may be best to file two separate I-539s along with your I-129, where your wife requests the same end date that you request and your daughter requests the shortened end date of when she turns 21. So that way your wife doesn't have to file an extra extension. Aditya has a common question that's coming up right now for H-1Bs that were approved in the lottery, wanting to know, can I change jobs now? In this particular situation, his company is getting ready to file for bankruptcy, so he doesn't really have a choice on that. My recommendation generally is to wait until October 1st to actually file the transfer. And the reason for that is a couple of years ago, USCIS started denying transfers that were filed before October 1st on the grounds that the person hasn't actually been counted in the cap yet because the H-1B has not taken effect yet. That seems to be very inconsistently applied, but if you have the chance to avoid that kind of denial by waiting, best to wait till October 1st to file the transfer. Now, you can work for the other company now based on your OPT or whatever your current status is. I'm assuming OPT or STEM OPT, as long as you know that your current company that has the H-1B approval doesn't plan on withdrawing it before October 1st. If they withdraw it before October 1st, you can't transfer it. It means that you've not been counted in the cap. It's as if the petition never existed.
I have this question from Surya from YouTube. How long can I work with the end client, different end client, without filing an amendment? 0 days. You cannot work with a different end client at a different MSA, and then you cannot work under the Simeo solutions of the Administrative Appeals Unit. You cannot work. You have to file an amendment, then only you can start working. We have seen a lot of people get into trouble because they start working before the amendment has been filed. A lot of denials, a lot of people getting into trouble. Be careful. Don't work until you get the H-1B amendment filed. You don't need to get it approved. You just need to file it.
Smitha wants to know how long USCIS is taking to renew the H-4 EAD. So that kind of depends. If you're just filing the H-4 EAD because you already have the H-4, then I would say the processing time is anywhere between 4 to 8 months, depending on which service center your I-765 goes to. If you're filing it along with your H-4 extension, it could take anywhere from 4 to 15 months, which means very likely that your current EAD is going to expire. And this is even if you file with an H-1B extension, and even if that H-1B extension is filed in premium processing, ever since they started this biometrics requirement for H-4 holders, it's for all I-539 applications, but we've noticed that, in the good old days, if you can call it that, earlier this year, if you filed the I-129 for the H-1, along with the I-539 for the H-4, along with the I-765 for the EAD, all together in premium processing, when the H-1 got approved, your H-4 and EAD got approved at the same time. Ever since the biometrics, they claim that they have to split up the processing because the biometrics causes the H-4 to be delayed, and they claimed that they were going to process them on a priority basis once the biometrics were done. They have not done that all. Every time we call customer service, they say, you're stuck with the normal I-539 processing times, which could, again, be anywhere from 4 to 15 months. Which is why we've been talking so much about filing a lawsuit, because that seems to be the only way to get the EAD on time, is by pushing USCIS to say, you have a duty to adjudicate any application within a reasonable period of time. Congress had said that 30 days is a reasonable period of time for
the
non-immigrant visa applications, and anything beyond 30 days is unreasonable and therefore arbitrary and capricious and a violation of the law. So you may end up having to file a lawsuit to get your EAD on
Manohar
time.
has this follow-up question on H-4 EAD litigation. Have you got any approvals from Nebraska Service Center that you filed a litigation? Yes, Manohar, we did get the approvals for the cases, litigation that we filed for H-4 EAD from Nebraska Service Center.
Krishna has a common question. Does upgrading an H-1B to premium processing have any impact on the chances of approval? So there's a huge myth or rumor out there that premium processing causes RFEs, premium processing causes denials, that those are more senior officers, so they're a lot more strict. Or because of the 15-day time window, they run out of time, so they just send an RFE to buy more time. I think all of that is not true. We file a lot of cases in premium processing. The cases that get denied in premium processing, I'm telling you, they would have been denied in regular processing. It makes people upset because they just paid $1,400 extra and ended up with a denial, but it's not the premium processing that caused the denial. It was the case.
Good question from Mahesh Rao from YouTube. He's asking the question, his priority date is December 2011. Is it worth for him to downgrade from EB2 to EB3? He upgraded it from EB3 to EB2. Since your priority date is not current right now, I don't think so it's appropriate for you to downgrade it, because you can always downgrade it at any point of time when the priority date becomes current. Since the priority date is not current, who knows, EB2 might move forward. So I wouldn't do it, but if you want to know exactly, you may want to discuss with a lawyer. At this point of time, I would advise not to do it if the priority date is not current. If the priority date is current under EB3 and it's not current under EB2, you should seriously consider downgrading it to EB3. Now, when you are upgrading from EB3 to EB2, you would require a labor certification, most probably 99% of the time. When you want to downgrade from EB2 to EB3, you don't need a labor certification. You can use the existing labor certification. That's the advantage of downgrading from EB2 to EB3, is that you won't require an labor certification. If the company wants to, they can use the same labor certification and downgrade to EB3. We have done several times using the labor certification, same labor certification, not a problem at all. But when you're upgrading, as I said, 99% of the time for upgrading, you would require labor certification, and you might already know that labor certification takes, at the minimum of 6 months to 12 months to get it adjudicated.
Anam has a good question. Speaking of priority dates and visa bulletins and all of that, how do I know my priority date is current? So it's a little confusing these days because we have 2 charts in the visa bulletin, but every month you have to go look at the visa bulletin. You have to find your category of employment-based. I'm assuming you're employment-based because that's what we typically talk about here. So you look up whether it's EB1, EB2, 3, 4, or 5 in the chart, and then you find your country of birth. If your country of birth is not listed, that means you use the all other categories, which is usually the first column, as the cutoff date. So if your date is if your priority date, which is the date your labor was filed most likely, if it's before the cutoff date listed in the chart for your country of birth and your category, then you're current and can file your 485. Now what gets confusing is there's two charts, a dates for filing chart and a final action date chart, and every month USCIS ultimately decides which chart you have to use. So you have to look at the visa bulletin on the State Department's website, then it takes you to the USCIS website to determine which chart to use. Right now for employment-based, you have to use the final action date chart, which is more backlogged. I expect that to continue for the rest of this fiscal year. Maybe in October when the new dates come out for next year, we'll be able to use the filing dates chart again.
This is a good question that is a more personal question, Emily. Is it expensive to file a H-4EAD lawsuit?
That's a great question. I would say that it's probably less expensive than you think, and it's on the same par as premium processing.
It's a little bit higher.
A little bit higher than that, but it's
a little bit higher than premium processing.
In range of that.
Yeah, it's definitely in range. It's higher than premium processing. Now, here is how REDDY and Neumann PC have cut down the cost on it. And if we were to litigate for one person, definitely it's going to cost. So we club together all the people, and then that's how, if somebody wants to join in, we give a discounted price. Instead of, if somebody wants to file one lawsuit for themselves, it may cost a lot of money, but if it's just a club of people, which we do, a lot of people fall into the criteria that the spouse's H-1B must be approved, the H-4 must have been filed more than 1 month ago, the fingerprints have been done. If you meet those requirements, you will fall into the category and you can plug into it and get the better price than if you were to file yourself.
And if you think about it, if you have to stop working or you're going to lose your job for 1 month, 2 months, 3 months, even just 1 month, the litigation is probably less than
minimum wages for 1 month.
Salary. So you take less than 1 month's salary that you're going to lose from not getting your EAD card and pay for litigation instead. I think it's...
and that is including of the filing fees we're speaking about.
Ramesh has a really good question, and I wish I knew the answer. Are we expecting premium processing to shut down again this year? Every time it's happened, it's kind of come as a surprise. We don't get any advance warning of it. It tends to happen when processing times for extensions without change get longer and longer and longer, and we have not seen that. They've actually been getting slightly better. And recently, it's actually starting this month, they've added the Texas Service Center as one of the I-129 processing centers. So now we have 4 service centers that handle H-1Bs. So I think that hopefully that will help spread the work around so that we don't get stuck with huge backlogs and then have to shut off premium this time.
Arpita has this question: what is a better option, H-4 EAD or F-1? Right now I'm in H-4. Arpita, H-4 EAD is a better option if you want to work. If you want to go to school and get the education, then F-1 is a better option. F-1 may be a better option. But if you want to go join a school to get a work permit, that's actually a violation of status. We know some of those 3 universities that are issuing. 2 of the universities starts with C, and 2 universities' names start with C, and 1 starts with H. I don't want to name them right now. They are issuing day 1 CPTs on the day 1 you join the university. We don't consider those universities as legitimate university. We've been telling all the people those are not legitimate universities. So we don't advise people to go on day 1 CPTs. It's been said so many times in many of our things, and you have seen University of Farmington. We may consider, I'm thinking that some of these 3 universities might be a sting operation. Who knows? So if you want to work, H-4 EAD is a better option. If you just want to go to school, get the education, F-1 may be a better option for you.
Yeah, and with those schools now, I'm seeing that they offer an executive PhD program to provide the day 1 CPT so that you can work full-time and go to school 3 days a semester for a
6 days a year.
PhD.
6 days a year.
You have to question the validity of a PhD program like that. So if it sounds too good to be true, it probably is, as the saying goes. Maheshwar has a question about the 60-day grace period. Is it okay to use like all 60 days of the grace period before finding another job, or should I hurry up and file the change of status to H4 instead? So you can use all 60 days. You just have to make sure that, you know, by the time you get that job offer, you have enough time to get the LCA, because that takes 7 days, get all the paperwork of your employer signed and filed within the 60-day period. But there's nothing, you know, if it gets there on the 60th day, that's totally fine. You do have a full 60 days.
Here is my question, Emily. Let's say, for example, I lose the job on July 1st. Should I immediately file a H4, or should I file a H4 60 days, that will be August, let's say 29th? Should I file, I wait until August 25th or so and then file for H4 at that point of time?
Yeah, my general recommendation is to wait until the last minute and file it only if you have to. Because if you hurry up and file the H4 and then a month later you get a job offer, you're no longer in the grace period. You're in a period of authorized stay based on a pending H4. And when you file your new H1, it is not going to be a transfer. It's going to be a change of status from H4 to H1. But guess what? You're not in H4 yet. You don't have an approval. So your H1 is now going to have to wait until you get your H4 approved so that you can change your status back to H1. Or you're going to end up with your H1 approved without a new I-94 card because you didn't have the H4 approval in time. So there's no need to hurry up and rush to switch to the H4. Use the grace period, take the time to find the new job. If you do, great, you can file it as a regular old transfer, nothing different about it. If you don't, then you file the change of status to H4. But if you file the H4 right away, you lose the opportunity to use the grace period and no longer can file a transfer.
A couple of quick questions. Does we need to do biometrics every time we extend the H4? The answer is unfortunately yes. Another question that came out for you, Emily, is that, oh, you said executive PhD. If I complete the executive PhD with 6 days of college time, will I be eligible for EB1? First, people need to know that EB1 is not as easy as you think. It's not like any doctorate can just go and just walk in and get a EB1. It's a very complex issue. That EB1, there are 3 categories: EB1A category, which is extraordinary ability; EB1B category, which is outstanding researcher, that most probably the doctorates will shoot for, but it requires a lot more things than just getting a doctorate degree. And that to a doctorate degree, which is executive, that only requires your 6 days of presence every year. I doubt very sincerely that it will be approved.
Mm-hmm. Suketu wants to know, what is the difference between an NOIR and an NOID? So an NOIR stands for Notice of Intent to Revoke, and an NOID stands for Notice of Intent to Deny. So the difference is an NOID is more like an RFE, a request for evidence. It happens before the adjudication of the case. So before they're going to make a decision, they're telling you, you know what, we intend to deny this case because of whatever reason, unless you can prove to us otherwise. So it's like a very serious form of an RFE, and you only have 30 days to respond to it. An NOIR happens after you've already received the approval. Now they're saying, wait, we changed our mind. We intend to revoke that approval because of new information that's come available. Either we think we made an error when we approved your petition, or we did a site visit and new facts have come to light, or you went for visa stamping and the information that you gave at the visa interview didn't match the information that was given in the petition. All of those are very common reasons for notice of intent to revoke. Both of them you only have 30 days to respond to and need to be taken very seriously.
Emily, I need your attention on this Ganesh question of YouTube. The best question that I've ever seen, probably in the past 1 month, is that he has his I-140 approved. His wife is going for F1 stamping. Will it be a trouble?
Yes. Yes, absolutely.
Why?
Yeah, I mean, so you have to remember that the F1 does not allow for dual intent, meaning you can only get an F1 if you can convince the officer that you are not an intending immigrant. When your spouse has filed an I-140, that means your spouse is clearly an intending immigrant. An I-140 is called an immigrant petition. So it would be very difficult for your wife to say, no, I intend to return to my home country when I finish my master's, while my husband is over in the US getting ready to get his green card. Even if he's not able to get the green card for 100 years, he still has the intent of being an immigrant. So it's very unlikely that she's going to be able to get the F1 visa stamp. I would not try it.
In the application form of 1560 DS-230 form, you need to mention that the green card application has been filed on her husband's behalf and she's the dependent beneficiary in there. So that is an absolute requirement. If by any chance you don't answer that, you may be considered that you have committed fraud. So be careful on those things. I don't know whether I would send my wife for stamping.
I guess time for one last question. This one is going to be coming up. Swati has her OPT ended already just last week, and her H-1B was selected in the lottery, but it's still pending. So as of right now, she has the cap gap, which extends her OPT from last week through September 30th. But what happens if the H-1B is still pending on September 30th? We had a huge number of people that were in that situation last year because we didn't have any premium processing. We do have premium processing this year, so hopefully it won't be as bad of a situation. But if your H-1B is still pending on October 1st, you have to stop working. Your cap gap employment authorization ends. You begin your 60-day F1 grace period. During those 60 days, you can choose to continue your F1 status, or you can stay in the U.S. based on your pending change of status. But the most important thing is no employment authorization beginning October 1st when the cap gap ends.
Thank you guys for coming in. If you want to consult with me or Emily, you can always make an appointment. Our schedules are available at RN Law Group. We strongly recommend to make appointments with our colleagues who are very good people and they are very talented people. You can make their schedules are also available at rnlawgroup.com. Don't forget to subscribe to our news at rnlawgroup.com and also immigrationgirl.com with Emily. And Emily does the blogging in Immigration Girl.
Thanks for joining us.
Thank you.